should I name my product? So your advice to them when they are in the initial stage, what they should, take into consideration, before they actually proceed to the filing itself.
Yeah. So hi, Hannah, and welcome to you as well as all the organizers and participants. So typically, I've seen that entrepreneurs tend to have, or they tend to pick a brand name that has some reference to their business or the products that they are selling. Now, for example, let's say you have a shampoo manufacturing company. It's possible you might think that the word Silky Shine is actually a great brand. But actually, that's a really bad idea because by picking words like these, it means you're making your trademark descriptive, which in trademark law is actually a big no-no. So you have to really think deep about what kind of trademark you want to adopt. And I would say, and I think every trademark lawyer would advise that the best kind of trademark that you can conceive of is a coined trademark or a coined word, an invented word that you have just, come up with on your own. It's something that does not have any meaning in the dictionary. So some very famous examples that I can tell you, for example, Rolex, which is quite famous for watches. Similarly, I'm sure many of you have heard of Kodak. These are all coined trademarks, and these kind of trademarks rarely face objections, and they simply sail through the examination process, and they're likely to get registered fairly quickly. Another type of trademark you can consider adopting are dictionary words or arbitrary trademarks. So arbitrary trademarks are basically dictionary words that don't have any reference to the products in question. So if I have to explain this, for example, if you take the word apple, and if your company or your product is apple juice, it's a bad trademark. But if you pick the trademark apple and you have computers as your product, then that's a very good trademark. And that's exactly what Apple Inc. did. And as all of you know, Apple Inc. is a well-established company today. So Apple would be a good example of use of an arbitrary trademark. Another category of trademarks that you can think of is like a logo, where you can have some artistic elements, where you can have visually appealing elements, as well as maybe some words. That's totally up to you. So these are called composite marks. These are also a good category of trademarks. And just to reiterate, descriptive and generic marks should be avoided very strongly because this is one of the major problems that a lot of entrepreneurs face. Some of you may have seen this Indian show called Shark Tank. It's basically an American show which has recently developed the Indian version, and it's quite popular in the country today. So perhaps some of you have seen it. And if you've seen the show, you may have seen a lot of young entrepreneurs, including startups and small businesses, have started adopting a lot of trademarks that are descriptive, like I was saying. Like there was an example of, in one episode that I saw, there was a company called Store My Goods, which is basically used, what they do is they store your goods when you're away. So that's very descriptive. Similarly, there was another product called In a Can, which was selling canned cocktails. So again, these are not great trademarks, and often entrepreneurs have a tendency to just tweak one letter and claim that the trademark is coined. So if, let's say, you have a weight loss app and maybe you want to call it BFit, like the letter BFIT, but this is still not a good trademark. As a contrast, you can consider a trademark like Starbucks. I'm sure all of you have seen the coffee chain Starbucks in many parts of the country. This is a completely coined original name that has no reference to coffee, which is the product that this company sells. And therefore, it's a great example of a coin mark. So while nobody can stop you from adopting descriptive marks, what happens is that if you have a coin mark, it will help you differentiate from your competitors and you'll really stand out. So for example, a few minutes ago, I said, gave the example of a trademark called BFit for a weight loss app. Now, if there are other apps out there called Become Fit, Beyond Fit, etc., the chances are that the consumer is not going to remember you, and they're probably going to get confused with your competitors as well. So this actually tends to do more harm than good to your business. So it's very important that you try to come up with a trademark that is nothing like what anybody else has, because the more you stand out, the more your name will be remembered amongst potential consumers. And just one last point, you'll also face an issue in enforcement if you don't have a good trademark, because what happens is when you're coming up with the business, you may not give it so much importance, you may not give it much thought. But as your business takes off and your brand really becomes valuable, you will see more and more knockoffs appearing in the market. And then obviously you would want to take action against them. So if at that point your trademark is going to be a very weak or a descriptive mark, the chances are that you may not succeed in taking action against them. Because there is case law in India today that says, where courts have held that deliberate misspelling of descriptive words does not change the legal position, and there can be no exclusivity over descriptive words. Yeah, Hannah.
Thank you, Aishwarya. And I think this is just my 5 cents here, and you might have different opinion. I also think that, if you start your business with, let's say, certain field, and then you grow as a company and you expand to another areas, then you are really limited by what you call yourself initially. And we have also seen it, I think, I don't want to say names. There is a company which started with the products for, going to bathroom for ladies. And now they expanded to all various fields, but they are kind of stuck with this interesting name, So, and also one more thing, as a foreigner, and I've seen it in India a lot, when you as a startup are thinking about expanding to foreign countries, sometimes people tend to stick to Hindi names, Sanskrit names, or very complicated Indian names, which is absolutely unpronounceable for foreign audience. And then again, it would be difficult in case you are thinking, in the future expanding to foreign markets to actually, be memorizable, because people will never, remember the name, So this is also my 5 cents from my perspective, what I have seen in India a lot. And sometimes I think why people call themselves that way, because it's for foreigners you can't actually never remember. I don't know, what's your thought on that, Aishwarya?
Yeah, actually, that's quite true. And especially, I think your first point is quite relevant, because as a startup, you start small, but then the ultimate aim is to become big. And then as you can scale your business only with sort of branching off into diverse areas. So you're completely right when you say that if you choose a kind of brand name that is very limited and has a direct reference to a particular product that you're offering, it kind of limits your ability to use that same trademark for a different product. Of course, as a business, one does have the option of coming up with more trademarks for different products and different sub-brands that businesses may want to develop. But I do get your point on having to limit oneself if it's too descriptive. I agree with that.
Yeah, I think the whole point when we talked about IPR in all these series was about approaching patent rights or any actually IP rights with a strategy, where there is a certain aspect when you plan, it's not just a random, okay, now I have to file something and, have to done as cheaply as possible and don't have time to think about it that much. It is your investment for your future. And I always keep saying that. I will copyright the sentence, but it's very true. And I think, Aishwarya, you've probably seen it in your personal experience over and over again.
Yeah, and in fact, I would also say at the beginning, when you're starting off, it's also important to budget your some funds for your IP protection, because often IP is something that gets sidelined. And like I said, when you're starting off, maybe your focus is more on marketing and other aspects of the business and not so much on IP. But as your business becomes successful, I'm sure you would want to develop your IP and also protect your IP. And by protect your IP, I mean going after other people who want to copy you. And if you're successful, there is no doubt that there will be people who will try to ride upon that goodwill and reputation that you have very carefully built up in the country, and who try to take advantage of that. And that's obviously something super unfair, because you have spent so many years, so much of effort and time and money in developing your brand, and you wouldn't want someone to take an easy ride on it. So it's also equally important for businesses when they start out to allocate and think about what kind of budget they want to spend on IP development and IP protection as their business grows.
And since we speak about budgeting, I think it goes naturally to the next question, should I file for the trademark or not? I mean, there might be already some startups who might be already active or trying to brand themselves. and they might feel that they don't have the budget to do that. What are your thoughts on that? And of course, if I do not file the application for trademark, what are the consequences?
Yeah, so it's not mandatory to file a trademark application. You could even simply start using your trademark straight away. You would still have unregistered common law rights over your trademark. The issue is not going to be when you use it. The issue is going to be, again, I'm reiterating my earlier point of as your business becomes more successful and bigger, and there may be competitors out there who try to copy you. So the issue is going to crop up when it comes to enforcement, because when you have to sue someone or when you have to take legal action against someone, if you have a registered right, a statutory right, which you'll basically get if you register your trademark and you have a registration certificate, then the burden of proof is much lower on you to when you have to plead your case in court. Because if you don't have a trademark registration, you will have to show a lot of other factors in court, such as reputation and misrepresentation, damages, etc. And that's actually often a tough call. I mean, there's a lot more evidence that you'll need to file in your pleadings, and therefore it becomes easier if you have a trademark registration. In today's times, it's not particularly that expensive or cumbersome. So I would definitely encourage all owners, especially if they're using the mark, which means they are already, they have invested a good amount of time and effort into the brand. In those situations, I would definitely encourage them to go ahead and also file an application for the trademark.
Yeah, and I think that naturally also answers pretty much the next question. If I'm already using my logo, name, whatever on products and services, whether that will have any impact on my trademark application.
Yeah. So if you're already using your trademark, then you need to file your application with a claim of use. And basically what that means is when you file your trademark details, along with that, you'll also have to indicate since when you have been using the mark in India. So the date of first use, let's say January 1st, 2020, for example. And along with your application, you also need to file a very short affidavit of use, which has to be accompanied by some documentary evidence. This could be things like sales invoices, it could be advertisements, it could be some awards that you won, some articles in the media, some publicity material, etc. And it's important on this point that I just want to touch upon. It's important here that your user information is very nicely compiled and collated and kept with the business, because this is going to help you on two fronts. One is when you file the trademark application, you will require this information to show that the mark is in use. And the second is, again, when it comes to enforcement. If tomorrow somebody is using a similar trademark and you want to take action against them, and if they claim that they have been using it for 2 years and you say that you've been using it for 4 years, you'll have to prove all your arguments. So when you have all these user documents ready with you, this really goes a long way in helping you successfully take action against these entities. So you need to collate these documents, because a lot of times businesses I've seen are quite casual about the user information. Sometimes they don't know the exact date when really they started using the mark, or they may have some random documents which are perhaps not clearly dated. They may not be legible. Sometimes the mark is not clearly visible. So it's those kind of documents are not going to help you. You need to have documents like if it's let's say it's a press clipping, you have to make sure that the date is clearly visible and that the brand, your mark, is mentioned in that article. Because if it is, then that is good evidence.
Yeah, and I would also mention a little bit a slightly different thing here that because we have seen it, and of course the whole point of IPR is talk about the protection, but also enforcement. And sometimes the let's say counterfeiting or infringement on the trademarks can be also that people are not aware of certain things. For example, let's say you go to holiday to Spain or you go to holiday to Italy and you see some catchy name somewhere and you think, that could be nice if I use it in India. Again, this is not a good idea. And in case obviously the company in the other country finds out that this is the case, although you might not doing, on purpose, but obviously you cannot use somebody else's name for a trademark in India, despite the fact the company is not here. I don't know, Ashwarya, whether you have any thoughts on this?
Yeah, so trademark rights are essentially territorial, but you're right because a lot of companies do have business interests worldwide, especially like multinational corporations. I mean, it could be a Spanish company, but it could very much have a business operation in India as well, and therefore they would have an interest in monitoring the Indian market and taking action against any kind of infringers that are there in India. And I have seen this in my practice also, where somebody would have just filed a trademark application which has clearly been copied because it would be identical to the foreign name and it could be something very unique. So you know that there is some amount of malafide involved. So yeah, I mean, just because the person that you copied from is abroad doesn't mean that you are safe and that it's okay for you to use that same trademark in India. You could be pursued by that company as well.
Yeah, it's because sometimes people might not be aware of that particular issue. Just kind of, I think, especially if you're a young company just starting out and you have this idea of going abroad. But even making it big in India, it's important to kind of respect everybody else's creation of mind, so to say.
Yeah.
And since we speak about, prior use, obviously the question of trademark search comes up. So Ashwarya, again, why do you think it's so important to do your trademark search?
Yeah, so this is again, I think, a very relevant question. And a lot of times, what I have seen is businesses tend to skip this stage. They think they don't want to really spend time and energy on searching a trademark, even if it's through another firm. They want to save the cost, basically. And so they skip this step. But this is a very short sighted decision because if there is another trademark out there and you've already filed your application without searching, chances are that the other similar identical mark, which is already on the register, it's going to block you in the future because that mark is going to get cited as a prior mark for you when your mark is examined. So just simply put, for the benefit of the audience, examination of a trademark is a process that happens at the trademarks registry. And the examiners, they search the trademark of register, the register of trademarks, to see if there's any other mark out there that is identical or similar to yours. And if there is, they will issue an examination report which will have certain objections, including the fact that this particular mark is already on the register, so why should we register yours? So these days, examiners take quite a strict view. So if there's like a prior identical mark, there's very high chance that yours will get refused. So you may have initially saved the cost of doing the search, but in the long run, when you think about it, if your mark eventually gets refused, that saving of cost was pointless because now you kind of have to start from scratch and you'll have to find another trademark perhaps that you want to file. So this is something that's not advisable, that you skip the trademark searching process. And also, if by chance, let's say your mark is accepted for advertisement, even then there is a possibility that the owner of the earlier mark could still file an opposition against your mark. So this means that again, your trademark will get blocked because then you have to go through the whole opposition process, which could take several years. On the other hand, if you've done your timely trademark search, you've got a confirmation that there's no other mark out there that's similar or identical to yours, and then you go ahead and file the application, it's quite possible that in the examination stage, the mark may straight away be accepted for advertisement. And if that happens, you could get your trademark registration as quickly as maybe even 6 to 8 months, which is super fast even if you look at it from a global perspective. So I would strongly recommend to all the businesses to always do a trademark availability search prior to filing their application. So once you have conceived your trademark, once you know what is the word that you want to adopt, run a search for it through the particular class where you are seeking protection. And if clear, then go ahead and file the application.
Yeah, thank you, Ashwarya. And I think I would just mention here that except for the Indian Trademark Register, you can also use the TMBU, which is the global one. And again, this is bearing in mind that you might want to go in the future elsewhere, So again, having the certain strategy, okay, now I'm in India, but my vision is to go to Germany or Europe or US, wherever it is, taking the broader perspective. If you have limited budget, there are free databases where you can do quite a few things on your own. But of course, if you have your trademark attorney in India, they can also advise you and help you with that, So it's not, and I think these days, these costs for trademark searches are quite affordable. And as as Ashwarya say, you end up saving actually at the end. It might not look like at the beginning, but yes, at the end it will be saving for you.
Yeah, and just to add to that, also, be it India or abroad, I would always suggest that you do the clearance search through an attorney, because often there may be marks picked up in the search which are very subjective to decide whether or not it's relevant. So you need that legal input there, because as a business owner, you may not necessarily uh, be in the right position to take a call on whether this mark is going to block you in the future or not. So this is definitely a stage where some legal advice is required. And like I said, this is a very important stage, because if you clear this, then it's pretty much a guarantee that you'll get your trademark without much issue. So it's important that you consult the right people, and don't take decisions by yourself and just do the search yourself and think it's clear or not clear. It's always advisable, be it for an Indian lawyer or a lawyer abroad, you consult an attorney for the trademark searching process specifically.
Thank you. And since we talk about, we have done our trademark search and now we are ready to file our application. So what is the procedure like?
So the process is pretty straightforward. Once you've done your search and presuming it's clear, you can file a trademark application online. You just need the basic details like the name of the applicant, address, and image of the mark. User information is mandatory. So either you file the application on a proposed to be use basis if you've not commenced use, or if you have commenced use, then you need to give the date and month and year of when use first commenced in India. And other than this, the only documentation you need is really a power of attorney if you're doing it through an attorney or an agent. And if you're a startup or a small business MSME, then you can also submit your certificate, because this will then enable you to take benefit of the reduced cost. There is actually a good rebate that is offered to startups in India by the government to kind of encourage and incentivize them to protect their IP. So for trademarks like online filing, official fee for a startup or a small company would be 4,500 rupees per mark per class. Whereas for all other companies, like a regular company, it would be 9,000 rupees. So as you can see, there is a good discount that is offered if you are a startup. And you just need to give your startup certificate to get the benefit of this discount. Yeah.
Yeah, and I think it's also worth mentioning here that once you get your trademark registered, it's valid for 10 years, and you can renew your trademark after 10 years. So you can have a continuous use as long as you're paying the renewal fees.
Yeah, so the trademark becomes due for renewal every 10 years, and this 10 years starts from the date of application. So if I file the application in 2020 and it gets registered in 2021, it will be due for renewal in 2030, which is 10 years from the date that you filed the application. And you're right, trademarks can be renewed in perpetuity. You just have to keep paying the renewal fee once in 10 years. It's pretty straightforward process. And these days renewals happen very quickly because everything is digitized and automated. So yeah, I mean, you just need to keep tab of the renewal date when it's due, and you can seek and give instructions to renew the trademark accordingly.
Yeah, I think this is in comparison to other rights where patent, of course, only for 20 years, industrial design 10 plus 5, copyright is 60. But so you can actually, as long as you are in business, you can renewing it, which is obviously good news that it doesn't expire per se. Yeah.
That's true. That's true. And also filing and protecting a trademark is also, from a cost perspective, it's a lot cheaper than filing some of the other applications like a patent application, for example. So it's not a very big investment, but it's an important investment, and you can keep renewing it in perpetuity and have your trademark with you for a very long time.
Yeah. And the last question is obviously how quickly. I know you already mentioned that if everything is okay, trademark application can be registered within 6 months. I have myself seen cases of trademark registration within 6 months. Generally, as per your experience, what would you say it's the kind of standard time?
Yeah. So again, if you follow the kind of suggestions that I gave in the beginning of this talk, in those situations, I can pretty much guarantee that there is high possibility of your trademark being registered within 6 to 8 months, which is fairly quick. But on the other hand, if you go and adopt, suppose you file an application without doing the proper search, and then in examination there is another prior mark that turns up, or let's say you file a trademark that's very descriptive, that is not a coined word, it's not a good trademark, then it's going to be again hit by an objection. And all these obstacles are going to go a long way in stalling your trademark registration. So that's why the first part of my talk, where I kind of spoke about what are the key things to keep in mind while adopting a good trademark, it's very important, because this is what will kind of determine how quickly your mark is eventually going to get registered. Because if you don't follow that, then if you're hit with objections at the TM office, or if a third party files an opposition against you, then your mark could actually be stuck for several months, and in some cases even a few years.
So thank you. I think we kind of completed all the questions. We still have a bit of time, so I would ask our participants to ask us some question you might have. Meanwhile, I'll ask Ashpriya one more question. This is also, I think, interesting for you, and also for me, since trademarks are not my specialty per se. I think, Ashwarya, that in India you have to, if you are using trademark, you also have to use it, right? That there is obligation of use, and if the trademark is not used, a third party can ask for its cancellation. Is that so?
Yeah, that's partly correct, in the sense that when you file the application, you can file it on a proposed to be used basis. There's no issue. The pressure to start using the mark kind of starts after you get registration. So your trademark can become vulnerable to a non-use cancellation action by a third party, which is basically a petition filed by somebody saying, take this mark off the register because it's not in use. This can happen only 5 years and 3 months after the trademark is registered, from the date that it's entered into the register of trademarks. So until such time, you do have sort of time to think about it and, start your manufacturing process and get your systems in place and all, unlike some other countries where there is a use obligation on the owner much earlier. So in India, it's not that early, but yeah, if you've registered your trademark and 5 years have passed and you've still not bothered to start use, it does become vulnerable to a non-use cancellation action by any interested third party.
Yeah, because my experience where I had, a friend who had manufacturing company, and there was actually trademark on their business filed by somebody else elsewhere, which was not used. Of course, India is a big country, right? So who knows who is doing what, Punjab in Chennai, right? So it's a big country, so it might happen. And this year they are now trying to kind of get there to have that particular trademark cancelled because nobody's using it, and they are very successful business. So it is something also to think about. And I think the point behind this also that there is not blockage of somebody else's trademark, isn't it? If I understood it correctly.
Yeah. So you can file actually a cancellation action on two grounds. One is that the entry is wrongly remaining on the register, and the other ground is that non-use, which we have just discussed. So entry wrongly remaining on the register would be, let's say there's a company, Sheraton, and somebody is registered Sheraton without any basis. Then Sheraton, which is a hotel chain, they can file a action against them on the ground that the entry is wrongly remaining on the register and it should be struck off. So yeah, there are other considerations also to keep in mind on the basis of which somebody's mark could get cancelled.
Thank you. So we have a few questions here. From Somajit. What would be the appropriate days to get trademark logo? I'm not 100% sure what you mean appropriate days. So maybe if you can revise the question a little bit, Somajit, and get back to us on that. And then from Kripa, which is the international website where we can check. I assume you mean the trademark search. That's TMVU, or obviously depending on jurisdiction, you have the national patent offices in the same manner as the Indian patent office would have their own register where you can check. For example, in Europe, it's the EU IPO, which they have the register of the trademark. TMVU, I think, does the global coverage, if I'm not mistaken.
In a lot of countries like UK, Singapore, USA, a lot of these countries, and even India for that matter, we all have our own national IP office's website is digitized. You can search for trademarks on the website itself. It's pretty self-explanatory. You can just Google like US Trademarks Office and you'll be taken to the website. And over there, you'll see a section for searching. And over there, you can just type your whatever the trademark is that you need to search, and the result will throw up a lot of marks that are registered or pending and a lot of details. All countries don't have this, but most of the English-speaking countries, all the major countries, they do have this. So you can, this is something that you can check online for many of the countries. Yeah.
Mm. Yeah, we still have 10 minutes, so please do ask us questions if you have any. I think obviously trademark is very important from the in the perspective of the brand, So the brand creation, because this is again, and I think Aishwarya, you might share that with us as well. If you become very successful business, you can also license your trademark. You can franchise your trademark. So it should be also seen in the same way as patents, that trademarks can also be in the future your source of revenues. Aishwarya, yes. Any thoughts on that?
Yeah, that's absolutely right. You can obviously license your brand, and in a lot of cases, you even see people selling their brands, which you can do by way of an assignment. And that is, in both cases, it's an agreement entered into both parties where they agree to license or assign. In assignment, it would be more a case of selling the brand, whereas in license, you're just authorizing someone to use the brand for a particular period of time, and you're still retaining the trademark rights to that. But definitely that is a way of monetizing on your business, and one should be very careful. Again, this is another thing that where you need to have a legal opinion. You need to have a good attorney draft these agreements for you to make sure that your rights are well protected and you're getting the best out of the IP that you have.
Yeah, but I think from the perspective of the strategy, this is again for startups, small companies which are just starting, to be aware of it, that in the future there is this type of possibility. Because generally when we talk about licensing, we naturally think about patents, we don't franchising like McDonald's, for instance. Think about trademark Starbucks, right? They are big brands, although there are a lot of work on the cases.
Correct, that's right. In fact, there are so many chains out there that do that, like for example, Subway,
or Starbucks, right? They are big brands which actually work on that model.
Perhaps KFC, Pizza Hut. In fact, there are so many chains out there that franchise, like for example, Subway, and again, it's important. Perhaps KFC, Pizza Hut, kind of even if you are a startup, you should franchises running the business even when you're starting, so that you can plan ahead, because again, you have a vision for your business and where it's going to take you. You kind of, even if you are a startup, why also I mentioned in between that even when you're starting, so that you can plan ahead, because I'm sure you have a vision for your business and where it's going to take care of your IP interests. And this is why to develop that as your business should also have, because often I've seen that the focus and the entire take care of your IP interests just goes into and to develop that and that side of the business, and because often I've seen that part of it, especially the focus and the entire revenue money that you spend on marketing your business, manufacturing, and that side of the business, and just the marketing budget, especially your IP interests, because money that you spend on marketing your business becomes successful. This but it's also important to the value of your entire business, your IP interests. Because intangible assets, as your business becomes successful, the value is going to really add to the value of your entire business. You can have licensing and assignment, intangible assets, and all of that. With these have intangible value as well, so they should not be sidelined a short while ago. Kept in mind as licensing and assignment, develop your vision, and all of that with these intangible assets.
So, whatever you are saying as well, when you will be
kept in mind as you
in the future,
develop your vision
this
for the
is
business.
Again, having any IP rights. So, up to whatever you are saying as well, when you
so in fact, I refer to this show Shark Tank in India, which is quite popular, and even the American version is quite popular. And so in fact, investors often ask show Shark Tank is India, do you have a patent, which is quite popular, and even the American version is quite popular. And one thing that investors often ask the importance of IP is, and if you have that protected, that means you are in a good position, you have a trademark registration action against third parties who are going to misuse your brand, potentially misuse your mark or product in the future. That means you are in a good position. This is why it's action against third parties who are going to misuse your brand, potentially misuse your mark or product in the future. Due credit. This is why I think from it is also value the revised question, basically what is the time frame to give it due credit. Own the trademark. I think I'm not sure what that means. Also, is it to register the revised question? Basically, what is the time frame? And regarding whether trademark is examined like patent, yes, that's I'm not right. Sure what that means. Also, is it to register also the is examined. So when you file the trademark, and it goes to the registry. There are examiners examined like patent. Yes, that's right. Then evaluate your application. Also is examined. So when you file the mark and details to see whether to the registry, there are examiners for the trademark who will then evaluate your application. That will go through check for is the mark and details to see whether it qualifies. So if you file the criteria for registration of a trademark, and so for example, one of the things your mark is going to get checked for is the mark distinctive. Mark is descriptive. So if you file for the mark, similarly, if you have basically a juice company, your mark is going to get rejected because they're going to just simply run a search and they will see that Apple. Similarly, if you already applied numerous registrations for Apple computers, so again they're going to reject your search and they will see that Apple there is already a prior mark has already obtained numerous registrations for Apple. You cannot. So again they're going to reject your mark because they just say that there is already a prior mark. So yes, that is basically the examination process, and an examination report is issued. You are subsequent and you are given the opportunity to respond to it. Typically within 1 month. That is basically the examination process, and an examination report is further evaluated by the examiner, and after examination either he will typically within 1 month, and once you file your response, then it is further evaluated by the examiner, and for the examination either he will to accept your appear and argue their case and to tell the or he may hearing officer why and the hearing is basically an opportunity for the applicant or their lawyer to appear and argue their case and to tell the hearing officer why their trademark should be granted registration.
I mean, my background is a patent, so in the prosecution of patent, we have a certain ways of curiosity because obviously, I mean, my background is a trademark, so you can maybe prosecution of patent, we have a certain ways of amend within the examination process. Would it be the same case for trademarks?
There are two types of amendments that are allowed. One is amendments to the trademark itself. So this amendment will be allowed only